Welcome to Nyay Pathshala. Nyay Pathshala is an online platform to empower the young advocates at the bar with the practical concept of law. It is essential because when I attended law college, service law was never a part of our curriculum. But when I joined the High Court, I found that about 60% of the litigation was in relation to service dispute. I found myself lost in the mirage of service dispute against which writ petitions were filed under Article 226 of the Constitution of India. For example, the concept of suspension, charge sheet, departmental proceedings, enquiry reports, and other allied concept of service jurisprudence were completely alien to me. With this in mind, I have chosen Nyay Pathshala as a platform to enlighten our junior members at the bar and other persons interested in this concept of service jurisprudence. In order to understand the concept of service jurisprudence, let us explore some basic concept or stages in a departmental proceeding against a government servant. We should remember that departmental proceedings for civil servants are thorough and meticulous. It is expected of civil servants to perform their duties with care, efficiency, and purpose, and for that reason only they are given different safeguards to protect against them from arbitrary actions. The proceedings of the departmental process is lengthy because there are always some safeguards, like a delinquent employee or a charged employee could not be penalized without following the principles of natural justice. At every opportunity, he must be given an opportunity to defend himself, and there should not be any element of bias against him. Under service law, there are two concepts related to a departmental inquiry or proceeding. One is preliminary inquiry and the other is a regular inquiry. Preliminary inquiry is normally conducted by the in-house department when there is a charge against the officer that he may be involved in some misconduct. In a preliminary inquiry, the delinquent employee may not be given an opportunity to cross-examine the witness, or he may not given the opportunity to look into the documents, because it is only to find out whether a prima facie there is prima facie evidence to proceed against the government employee who is suspected of any misconduct. But it is said that if a preliminary inquiry report is to be relied by the inquiry officer, then that has to be served to the delinquent employee or the charged officer. But if the preliminary inquiry is not relied during the inquiry proceeding, it need not be served. But once a regular inquiry is initiated, this preliminary inquiry becomes redundant. The primary purpose of a preliminary inquiry is to determine whether there is sufficient initial evidence against an officer to justify further proceedings. However, in cases where service rules allow, a preliminary inquiry may not be necessary before initiation of departmental proceedings. The next concept which is necessary to understand departmental proceeding is suspension. There may be two circumstances where an employee may be placed under suspension pending withdrawal of departmental proceedings. In scenario number one, a government servant is arrested and detained by the police for 48 hours in custody. In that cases or those circumstances, the government servant is deemed to be placed under suspension as he has been detained for 48 hours by the police. The second circumstances is that an allegation of misconduct is made against a government servant. When an allegation of misconduct is made against a government servant, and prima facie there is material to show that he may be involved in corruption or other activities which is prejudicial to the interest of the government, then a government servant may be placed under suspension. But suspension is never to be regarded as a punishment, and there are various judgments of the Supreme Court which says that suspension can't be considered as a punishment because it is simply a temporary interruption of the employer-employee relationship. As during the suspension, subsistence allowance is paid, say for example for the first 3 months he may be paid, for the first month he may be paid 50%, for the next 2 months he may be paid 75%. Since subsistence allowance is paid to a government servant during his period of suspension, he enjoys the benefit of his pay even without working. But there may be restriction that he may not be allowed to leave the headquarters without the prior permission of the superior authority. So an employee can be suspended either when a criminal case is pending or when a departmental inquiry is being considered. At this point, it is important to look into the judgment of the Supreme Court in Ajay Kumar Chaudhary versus Union of India, reported in 2015 7 SCC 291. In this case, the Supreme Court expressed disapproval of prolonged suspension and stressed that suspension should be of short duration. In this particular case, the Supreme Court directed that if within 3 months the delinquent officer or employee is not served with a memorandum of charges or charge sheet, the suspension order should not continue, and a reasoned order must be issued for its extension if the charge sheet is served. After suspension, the next stage in a departmental proceeding is issuance of show cause notice. Show cause notice is issued when a government official is prima facie held responsible for misconduct. Against the show cause notice, the delinquent gets an opportunity to submit his show cause reply, and in the show cause notice, the delinquent is informed that he is responsible for such misconduct. The show cause reply has to be submitted within a particular time frame, and if certain documents are relied on the show cause notice, the charged officer or the delinquent employee can always ask for the copies of those documents, and if those documents are allowed for inspection or allowed to take copies of it, the charged officer or the delinquent employee can take hold of this copy from the authorities. Once the show cause notice is issued, the charged employee or the delinquent has a right to reply against the show cause notice. But simply asking for the documents, if it is relied by the departmental authority, that may not be sufficient unless we show how prejudice is caused to us by non-supply of these documents. And that has been referred by the Honorable Supreme Court in the case of UP State Textile Corporation Limited versus PC Chaturpati, reported in 2005 8 SCC 211, where the Supreme Court had observed that in the absence of showing how the alleged non-supply of documents caused prejudice to the workman, the same cannot by itself vitiate the inquiry. After receipt of the show cause reply, if the departmental authority is not satisfied with the reply given by the charged officer or the delinquent employee, then it will file a charge sheet against the employee or the charged officer. The date of the charge sheet is important because it is only on the filing of the charge sheet that the departmental proceeding is initiated. Suppose a person is suspended on say about 10 years back, and the charge sheet is submitted after 10 years, then that may be a ground for challenging the charge sheet in some cases, but of course it will depend on the facts and circumstances of the case. In the case of Union of India versus KV Janakiram, which was reported in AIR 1991 SC 2010, the Honorable Supreme Court emphasized that the initiation of departmental proceedings against an employee can only be considered to have occurred when a formal charge memo in a disciplinary proceeding is issued to that employee. Along with the charge sheet, the statement of allegations, the list of documents that will be relied during the inquiry, the list of witnesses may also be furnished to the charged employee so that he knows that what he is charged with. The next stage will come for appointment of an inquiry officer to conduct a regular inquiry. To present the side on the case of the government or the management, a presenting officer is appointed who will place the case from the side of the government. The accused employee or the delinquent will also be given to have a defense assistance of his choice. It may be a retired government employee or an in-charge employee. It will depend on the service rule of that particular department. But normally, a lawyer is not allowed to defend the accused employee in a departmental proceeding. But in some of the cases in recent times, we have seen that if it can be shown that the departmental proceeding involves such intricate questions of law, and it is difficult for a layman like an accused employee to defend those allegations, then the inquiry officer may permit the assistance of a lawyer subject to what the service rule specifies in that regard. In the case of FCI versus Bansing, which was reported in AR 1997 SC 2982, it holds that the absence of a legal representation will not vitiate the inquiry proceedings. The next stage is attendance and questioning of the witnesses by the inquiry officer. The inquiry officer can himself also summon the witnesses. But we should remember that in the conduct of departmental proceedings, the provisions of the Indian Evidence Act 1872 shall not apply, and the authority conducting the departmental proceeding shall be governed by the rules of equity and natural justice. As part of a departmental inquiry, the department should lead evidence against the offender in the first instance. Then the charge officer will be given an opportunity to cross-examine the witnesses against him, and the inquiry officer has also the power to summon the witnesses. If the witnesses are not allowed to be cross-examined by the charged employee, then that may be a ground for setting aside the inquiry report. At this stage, let us understand the nature of proof in a departmental proceeding vis-a-vis criminal investigation. In a criminal investigation or trial, an accused must be proved that he had committed an offence beyond all reasonable doubt. But in case of a departmental proceeding, it is the concept of preponderance of probability. That means if you can prove that a certain fact or a certain act has been committed, then it is sufficient. Say for example, if in a criminal inquiry, say 90% you have to prove that the offence has been committed. In case of a departmental proceeding, if you can prove that the fact exists, say up to 60%, then the departmental proceeding may punish the charged officer or may take any other action against the charged officer. The next stage is the submission of the inquiry report. Once the inquiry has been concluded and the inquiry officer records his findings on the inquiry, then the copy has to be furnished to the delinquent or the charged officer. Normally, an inquiry report can only be challenged if the report is frivolous, it does not discuss the evidence which was presented in the inquiry, it simply exhibits a document. On those circumstances, an inquiry report can be challenged, including non-furnishing of the inquiry report to the charged officer, because that will be a violation of the principles of natural justice. In this regard, you should read the three of the cases. One is Union of India and others versus Mohammad Ramjan Khan, AR 1991 SC 471. Managing Director ECIL versus V. Karunakar, which is reported in 1993 4 SCC 727. And the third case is Punjab National Bank and others versus KK Verma. All these cases is important from the point of view of furnishing of the enquiry report, and third case deals after the 42nd amendment of the Constitution, what is the right given to a charged employee. In this third case, it was held that the right to represent against the findings in the enquiry report to prove one's innocence is distinct from the right to represent against the proposed penalty. It is only the second right to represent against the proposed penalty which was taken away by the 42nd amendment of the Constitution. The right to represent against the findings in the report is not disturbed in any way by the 42nd amendment of the Constitution. In fact, any denial thereof will make the final order vulnerable. It is to summarize that the requirement of second show cause notice of proposed punishment has been dispensed with by the 42nd amendment. The 42nd amendment of the Constitution deleted certain words appearing in clause 2 of Article 311 of the Constitution of India, which reads as under, quote unquote, and where it is proposed after such enquiry to impose on him any such penalty until he has been given a reasonable opportunity of making representation on the penalty proposed, but only on the basis of the evidence adduced during such enquiry, has been deleted. The requirement of second show cause notice stands specifically omitted by the 42nd amendment. In Kunj Bihari, this is again a famous case. In Kunj Bihari's Mishra's case, it was held that when the enquiry is in favor of the delinquent officer, it is not necessarily that enquiry report shall always go against the charged officer or the delinquent employee. At times the enquiry report may go in favor of the delinquent officer, or say there are 5 charges against the charged employee, but 2 of the charges are proved, 3 has not been proved, then what it will be the status. In Kunj Bihari case, it was categorically held by the Supreme Court that when the enquiry report is in favor of the delinquent officer, but the disciplinary authority proposed to differ with such conclusion, then the authority must give the delinquent an opportunity of being heard. Otherwise, he would be condemned unheard. Then the next stage after this, against the proposed findings of the inquiry, the delinquent serves replies to gives his reply, and after that, the departmental authority will look into the inquiry report, the reply of the charged employee, and it will decide to impose the penalty. And penalty is normally imposed depending upon the gravity of the misconduct committed by the employee, and what kinds of penalty will be imposed, the disciplinary authority will take a decision. But normally 2 kinds of penalties are noted in the service law. One is minor penalties, one is major penalty. Minor penalty includes censure, then withholding of increment of pay without cumulative effect. The second category of penalty is major penalties. What are major penalties? It may be reduction to a lower stage in the time scale of pay for a specific period, and which shall ordinarily not be a bar to promotion, compulsory retirement, removal from service, dismissal from service, withholding of promotion, recovery of pay. All these are major penalty. But at this point we should remember that in case of minor penalty, writ petition may not lie. It is only against a major penalty you can challenge it either before a central administrative tribunal or a state tribunal or before the High Court under Article 226 of the Constitution of India. Once the penalty has been imposed, there is always an administrative appeal which can be submitted by the charged employee against the penalty, and it provides a time frame to submit it within 45 days, and after that in some of the service rule we find that there is even a provision for condonation of delay if there is sufficient cause and the appeal is not filed within that 45 days. The last and the final stage after that, which the role of the lawyers come into play, is that if a civil servant is aggrieved with the decision of the disciplinary authority, what are the remedies available to them? As a citizen of India, a government employee has certain constitutional rights and he can seek the protection under the Constitution of India. If any action is taken against him which violates this right, then he can file a writ petition under Article 226 of the Constitution before the High Court, and in some rare cases under Article 32 of the Constitution before the Supreme Court. In some cases, if it is a state government employee, there may be provision for him to first go to the concerned state administrative tribunal and thereafter, if necessary, to the High Court and then to the Supreme Court. Similarly, in case of a central government employee, they have in the Central Administrative Tribunal Act, they have given some list of departments and organizations for which the service dispute has to be filed before the Central Administrative Tribunal. Then after the order of the Central Administrative Tribunal, it can be challenged before the High Court under Article 226 of the Constitution of India, and normally it is taken up by the division bench, orders which are under challenge of the Central Administrative Tribunal. The Honorable Supreme Court outlined 5 fundamental principles in Captain M. Paul Antony versus Bharat Gold Mines Limited, reported in 1999 3 SCC 679, which governed the conduct of both departmental and criminal cases. The first ratio was that simultaneous departmental proceedings and criminal proceedings are permitted and can operate separately and concurrently. The second ratio was that there are situations where it is advisable to postpone departmental proceedings when both criminal charges and departmental actions arise from the same set of facts. This is essentially significant when the criminal accusation is serious and involves complex legal and factual issues, and it may be prudent to wait for the outcome of the criminal case. The third is that when a criminal case involves intricate legal and factual aspect and serious charges have been made which depends on the evidence collected or stated in the charge sheet and the nature of the charge sheet, then in that case, this judgment clearly reflects the balancing factors which is essential or necessary for the timely management of the departmental proceedings. If the criminal case experiences delays or stalls, then departmental proceedings can be resumed and expedited. This means that even if they were initially suspended due to the pending criminal cases, they can be reactivated. If the employee is cleared of the charges, his reputation can be swiftly restored. And if he is found guilty, the organization can take prompt actions without hindrance. Within a limited time frame, it is always difficult to summarize all the concept of departmental proceeding. But I assure all of you that in the coming days, we will dissect each of the topics or issues related with departmental proceeding from the practical point of view. I hope that today's topic will benefit the young lawyers at the bar and it will help them in developing their advocacy skill.